Welcome everyone to this fabulous ACIL lecture that we are about to hear. It's my great pleasure to welcome Dimitri Van Den Meerssche. He is a senior lecturer in law and fellow of the Institute for Humanities and Social Sciences at Queen Mary University of London. His current research studies the impact of new digital technologies on global security governance with a focus on counterterrorism and border control. He is interested in forms of inequality and exclusion enacted by practices of algorithmic governance and how these practices impact political subjectivity and the prospects of collective action. Recent writing focused on the inequalities enacted at the virtual border, the phantom publics and value systems of algorithmic governance, and the subject of critique in international law and technology. His work is inspired by critical security studies, feminist technoscience, infrastructure and design theory, and critical Black studies. And maybe on a personal note, Dimitri has been a long-term companion and partner in crime in trying to think through what to make of technology from an international legal theory perspective and so on. So it's really wonderful that he is here today to speak to us about his research with the title Algorithmic Risk Governance, Mapping the Digital Bordering Infrastructure of Cerberus. And I would say without further ado, over to you.
Fabulous. Thank you so much. I'm going to stand up. Thanks so much, Andrea. Thanks to you all for coming. I've had a wonderful day already here at UvA with PhD researchers from whom I've learned an awful lot. So it's really great to be here. Before I get started, I should say that this all that I will be presenting as part of a collaboration with Gavin Sullivan at Edinburgh Law School and as part of Gavin's UKRI Future Leaders Fellowship, which has really enabled this project. And specifically the material on Cerberus, which I'll be speaking about, has been published recently in the German Law Journal. So this is part of the promo tour for that article. So please, please read it. It has taken us 2 years of research to compile it. I'll speak a bit more about that in a second. So today I'll talk about what Cerberus, this awkward creature, is, but also trying to focus a little bit about why this would be of importance to general audience of law and technology scholars, international legal scholars, socio-legal scholars, hopefully all of you in one form or another. So this is roughly the outline where this is the outline of the paper, but also of the talk today. So I'll be speaking about how Cerberus, so in 2 words, Cerberus is the new UK digital border control system, how it shows us a kind of reassemblage of the state. So that's the first part. Then I'll introduce the concept of the infrastructural Brussels effect, and then particularly I want to think about the governmentality that Cerberus entails. I won't linger too much on that. Also, I should say at the start, I have too many slides, probably. It's the first time I'm doing this talk. If at some point you hear me rushing, this is Amy's strategy that I learned today of accelerationism, of saying the same thing just by speaking incredibly fast. I hope it won't be necessary, but we'll see when we get there. So, what is Cerberus, this weird mythical creature? Some of you might know it from Greek mythology or from, I think it's a creature in Harry Potter as well. I'm not sure, like this multi-headed dog. I don't know why I look at you for Harry Potter. You have a daughter, so... But so Cerberus is part of the UK 2025 border control strategy, which has the not so humble aim to revolutionize the UK border and build resilient ports of the future. And the whole idea is to use artificial intelligence for advanced risk assessment systems, right? And this whole notion of risk assessment is basically, well, it's not enough that we stop the known risks at our border, the people who are on watch lists, the people who we know have committed crimes, the people who are looked for by Interpol or Europol. No, the orientation is towards the unknown risk, the threat that is as yet unknown. And this is, of course, a classic trope of preemptive security post 9/11, right? Where the idea is but it's not enough to know who the dangerous people are. You actually need systems to stop the people who you don't yet know who might be or will be dangerous. The famous unknown unknowns, for those of you in the kind of post-9/11 security sphere. And the basis of that is twofold. On the one hand, it's this promise of big data, bringing together, gathering together ever more eclectic, heterogeneous data in one kind of decision-making system. So collecting and fusing data together, and then combined with that, a more advanced analytics. So where unsupervised machine learning holds the promise of, in this swamp of eclectic heterogeneous data, to distill actionable patterns and insights that show you something that the human brain or the traditional administrative state would never have been able to perceive. The promise of that is to incrementally improve targeting capabilities to find and preempt the risk or threats as yet unknown. So these are all quotes from the 2025 UK border strategy, which is strikingly similar to this report from 2020. This is what is going on in the European Union. Not coincidentally, the report, the strategy on opportunities and challenges for the use of AI in border control, migration, and security has been written by Deloitte. And so a whole other talk could be about the role of private consultancy in the dissemination, distribution, and mainstreaming of these digital strategies, right? From security and austerity, from security to the world of austerity through the promise of big data. I would like to digress on that, but I'll restrain myself. So this is what we read in the EU strategy. It could be copy-paste in the UK strategy, right? DJ Home is excited to harness artificial intelligence for the benefit of its borders. Why is AI so promising? Because in conducting risk assessment on a group of individuals, AI will help us find patterns and cluster individuals for further investigation. It will give us classification categories of risk, that are not based on these crude old categories of nationality, citizenship, etc., but based on learned similarities between people detected in data. It will give us, it will help us to identify unknown persons of interest. So again, away from the known towards the unknown, based on data-based risk profiles. The line that I really love about that quote is, I use it very often. What is the mode of decision-making here? It's one based not on logic or causation, but the unsupervised uncovering of correlations, right? So it's Deloitte going all postmodern at the border. In doing so, I couldn't resist this animation suggestion by PowerPoint. Very cool. The system that has been developed is Cerberus. So Cerberus, the multi-headed hound of Hades, the watchdog of the underworld. So another whole talk could be about what it means that the UK decides to call its border control system after the watchdog of the underworld. Again, it's probably because they all went to Eton College or something like that. But the strategy aims to develop advanced risk assessment systems using AI-driven decision-making. And this is precisely what Cerberus is. So the reason why they called it Cerberus, I can only assume, is because Cerberus has many heads, right? And these many heads stand for the heterogeneous data, the many sources of data capture. Cerberus eats from everywhere, collects data from everywhere, and they come together in the one computational body, right? So one algorithmic system ingesting and processing many elements of heterogeneous data. This is the advanced risking system in the own words of... Yes.
Some of the big challenges that border force are facing is that they have data in silos, they have different ways of working across the different modes of transport. That's impacting the way in which they can protect the UK border. Cerberus provides real-time risk assessment, people and freight data moving across the border. It fuses together Home Office, industry, and government data. It then presents the information to the border force officers to give them the most complete picture of the movement that's coming across the border. And That then allows the officer to make an informed decision about the appropriate next course of action to take. Cerberus is really exciting because it's going to transform the way in which some of the workforce officers work. They previously had to do things in quite a manual way. This is going to provide them with all the information up front. It's really going to speed up what they do and allow them to spend more time actually doing the hardcore decision making that they need to do rather than looking for the information in the first place.
How can we help? Also, did you notice how she said Cerberus is really exciting? When it looked like this is really not at all exciting on her face. But so interestingly, what we see here is a brief explanation of Cerberus, real-time risk assessment based on machine learning technologies. But the person that you saw, and you saw it very briefly at the end, does not work here. This is where 2 years of our research were conducted. So this is the home office based in London, where Gavin and I had 3 series of full afternoon interviews with the Cerberus team, but also with these people, BAE Systems. So the woman you just saw works for BAE Systems, British Aerospace Engineering, which you might also known as one of the companies that is producing the F-35 fighter jets that are deployed in Gaza and assembling them. So the UK Home Office works together with one of the world's biggest weapon manufacturers who prides themselves not only on the infrastructure, military infrastructure, but also military intelligence. So the Cerberus team that is central to our research consists of both Home Office people and BAE Systems people. So that's quite an important part of the story. I'll tell a bit more about that in a second. So the team that gathered to build Cerberus consists of, so the people that were around the table with us, only enabled because of Gavin's UKRI project, were lawyers from the Home Office thinking about the question, how can we build this AI-driven risk assessment system in a way that is legally compliant? And then the BAE system people who were sitting there, we know how you build a machine learning-based risk assessment technology. And these people came together around Cerberus. There was also one very muscular guy in the corner of the room who never said a word. I really don't know who he was or what he was doing there. Gavin and I expected he was probably from the intelligence side of things. Now, an important element to that is the background of Brexit. So the whole reason why Cerberus exists, and this will become clear in more detail later, is that, of course, after Brexit, the whole promise was autonomy, take back control over our borders, but the UK is incredibly heavily reliant on EU-based security data. So this is data from the Schengen Information System, from those familiar with that. But also, and that's a key part, all the passenger name records and advanced passenger information. So this is the kind of stuff that you have to provide when you board a plane or even take the Eurostar from here to London. This data is really essential for that border control risk assessment apparatus. And once Brexit happened, the UK lost access to all of that data in principle. So they had to make, in the Trade and Cooperation Agreement with the EU, the TCA, they had to basically make a deal in order to keep that data. If we wouldn't have had the agreement, we wouldn't have had any of the data anymore. But the EU was really capable to make very firm demands on what they could do with it. So you have this kind of weird arrangement of Cerberus with the Home Office, BAE Systems, and then the kind of CGEU, EU legal machinery hovering in the background. So that's the setup. Now, some of you international lawyers might wonder why would we at all be interested in this niche UK border control digital system. So I want to argue that Cerberus gives us, or the socio-legal analysis we made of Cerberus gives us unique insight in 4 very important topics for international law as a whole. First of all, the question of where does legal change come from, right? So, of course, you have big legislative changes, new principles or resolutions get adopted. I'm thinking of Ingo and the work on semantic shifts and interpretative communities as an engine of change in international law. So the argument here is that if we want to understand some of the most important changes in international law today, what we have to look at is not the formal binding sources of Article 38 of the ICJ statute, not even the interpretative community gathering to give concrete meaning to these norms, but the socio-technical tools, the infrastructures, the algorithmic systems that give concrete meaning to legal norms in their materialization or their use. So that the deeper argument there is that the infrastructural, the material, the socio-technical has too long been neglected as an important side of normative and legal transformation. Secondly, then we want to intervene with what is maybe a niche debate, but familiar to at least one of you, I discovered this afternoon, the debate on law and infrastructure, right? To what extent is infrastructure a form of legal normativity, or to what extent is law and infrastructure? Our argument engages with that. Third, because thinking through algorithmic governance in the way that we do gives us important insights on where to look for power and where to demand accountability in the world today, beyond the very troubling narrow figures of like the human in the loop. So those of you who do law and technology scholarship or work will be very familiar with the human in the loop as this kind of random, very often deus ex machina, who we drop there as the final site for normative agency, responsibility, etc., and try to think about power and accountability beyond that. And finally, most broadly, to try to understand what we think is an emergent form of algorithmic governance or algorithmic governmentality, goes by the name of governance by data, doesn't really matter, that we see today as a ruling governmental rationale. So before we dig in, so the first part is about how Cerberus is not only having effects for people crossing the border and entails this distinct mode of governmentality, but also how Cerberus is actually reassembling or reconstituting the administrative state, or at least how Cerberus is an example of the transformation of the administrative state. In this case, the Home Office, but I think the insights travel more broadly. So Cerberus, the transformation is on two sides. This is Cerberus, right? The multi-headed watchdog of the underworld. On the other side, we have Helios. That's the second big system that is being introduced. So we have Helios, which is the god of the sun, the god of sight, right? So it's all Greek mythology at the Home Office. I would really have wanted to be in the meeting where they came up with these names. It's completely wild. And Helios this is the old state, right? This is the old logic, the known threat. People who have done things wrong, we put them on watch lists. It's the kind of post-9/11 UN Security Council watch listing apparatus, Interpol, Schengen Information System. These are the risks. These are the people who we know are dangerous. And of course, watch listing is not easy. It's a whole digital system as well. But then Helios works together with Cerberus. So this is the known threat, the known risk. Cerberus is the unknown threat, the unknown risk. So it's important to know that these two systems hang together. Now, the watch listing system that existed in the United Kingdom and in many other countries as well had actually many of the similar features that we could assign to the sovereign state or the administrative state, which were considered very problematic. Helios, the system preceding Helios, the watch listing system, was very centralized, which means all the data was collected in one place and only a limited number of people with special credentials high up in the administration had access to that list, right? So it was centralized, it was clunky, all the data that inserted had to be made compatible. Helios says we have to get rid of that. Our systems have to, first of all, become interoperable. So we go from data silos, data that is collected in different places, right, that is siloed, to what they call data federation, which is a kind of technical term to say you could do a search query or you could engage in a mode of analysis that actually searches across all of these different silos, right? One of the buzzwords in data security is this notion of interoperability. Also in the EU, we need to get away from that old siloed approach. The data has to speak to each other. Second buzzword, modularity. The system has to be made quick, adaptive, right? Like a startup. We need to be able to keep plugging new things in when we need them. You want to add biometrics to your watch listing system, the system has to be able to accommodate that. It has to be decentralized. It has to be able to expand horizontally without having to. So all the quotes that you see here, I should say, are all interview citations, right? We need to keep plugging things in. We need to be able to expand horizontally, but especially if you want to use AI, you need to make sure that your silos of data will only always have part of the answer. You need to have all the data in one place, one interviewee stated, so we can always access it and analyze it over time. The only point to AI is if you can make it search for associations and patterns and relations across data, and the more heterogeneous the data is, the better, actually. So what we have here, we argue, is a massive form of, I'm relying on my slides, so etc., infrastructural reform. So we move away from the centralized, the siloed, based on administrative delegation, the old state, let's say, right? The sort of sovereign, vertical, hierarchical state, towards a system that is much more adaptive, interoperable, modular. So I'm mentioning that because what we see here is a form of transformation, which Fleur Johns, for example, has described as the shift from planning to prototypes, new ways of being a state. So we did a symposium on that with Andrew Lang and de Val Desai, but also a piece by Andrea here and Marie Petersman on scalability, replicability. The point is that you want your state to look much more like a startup in Silicon Valley than like the old, clunky, slow administrative state. The data has to be made available fast. The system has to be decentralized, modular. You need to be able to develop algorithmic systems that search across all of these previously siloed data sources. So an important transformation of the Home Office is actually to get rid of all that old hierarchical, slow stuff and to replace it with much more sort of tech-friendly, modular, prototype-based forms of data storage and analysis. This is one of the most remarkable quotes from the Border Strategy, where they say, the private sector must take the lead on border innovation. So this is the border, the exponent of sovereign authority. One might say, this is the very constitutive force of modern sovereignty through the formulation of, or the delineation of territory. Now it's the private sector that must take the lead on border innovation, with the role of government being limited to, quote, creating an environment that encourages experimentation and technology adoption, right? So this is one of the most sort of powerful articulations of new ways of seeing like a state. Claudia Arado has described it as a form of experiments without protocols, a border experimentality that debilitates the migrant subject of experimentation. Because of course, experimentation implies trial and error, building from scratch, tweaking and tuning. This is not really a kind of process that you would want to have associated with violent exclusion at your sovereign edges, right? But this is precisely what we see, of course, private sector taking the lead. We see it not only in the development and design of Cerberus through the collaboration with one of the world's biggest weapon manufacturers, but we also see it in the fact that Cerberus, the whole decentralized, modular, adaptive system, is based on the cloud infrastructures of Amazon Web Services. So AWS was awarded €500 million or €500 million almost pounds contract for the cloud infrastructure of the Home Office of Cerberus. The scale of enclosure, this concept comes from Jennifer Cobb and Michael Veal, a process of enclosure of AI technological infrastructure, is so significant that the UK Competition and Markets Authority is actually investigating Amazon Web Services for breaching the UK antitrust rules by completely monopolizing the cloud infrastructure market, both on the private and on the public side. So we're going to evolve towards a system where private corporations are not only pivotal for new technologies of experimentalism, but also for actually owning the infrastructures on which border control, but also other forms of public service delivery depends. Some of you might have heard that during Meloni's visit to Trump's mansion, one of her meetings was with Elon Musk on how he could help her provide the cloud or build the cloud infrastructure for Italy's public service delivery systems. So this is a really important part of the Cerberus story, reassembling the state. Second argument is, the speed is so intense, or I'm incredibly out of shape. I don't know what's. The second dynamic at play here is what we call the infrastructural Brussels effect. So what does that refer to? By now, you will surely have understood that systems like Cerberus are very data hungry. They don't work unless you feed them continuously with eclectic data sources. Now, of course, the United Kingdom leaving the EU posed an enormous data problem. As I explained before, if they wouldn't have had the TCA, so the Trade and Cooperation Agreement, which has a whole chapter on information exchange in the security sector, they would have lost the most important data that they had access to prior. Now, of course, the EU was not just going to give away that data for free. The EU has very stringent rules on data exchange with third countries. Right? And the issue for the United Kingdom was particularly around data retention and automated processing of data. So this is a bit more the dry doctrinal part of the talk, bear with me. But for the UK, it's very important that if you want to use AI in risk analysis, that you can store the data for a very long time. Imagine someone crossed your border 3 years ago, right? And that person now commits a terrorist offense or is now associated with a terrorist group, right? You will want to have retroactively access to that data to find certain patterns in the data behavior of that person to then extrapolate that to other people and flag them as high risk, right? So if you lose that data retention capability, you're heavily restricted in your AI capacity. The second is in relation to automated processing and the whole EU legal apparatus around human in the loop, reasonable explanation, right to an explanation, etc. Now, the EU entered that negotiation kind of with their hands tied because there had just been the Court of Justice of the European Union, CJEU, Opinion 115 on EU data exchange with Canada. So Opinion 115 was about sharing data, was about the EU-Canada agreement, where the EU had actually said, or the CJEU had said, the EU cannot give the share data with Canada unless the data retention, so from the moment that a person leaves your country again, so they have arrived and then left again, the data has to be immediately deleted unless there is a reasonable suspicion that that person poses an illegal immigration, security, or whatever risk. Right? And you cannot use automated processing of data unless there is an objective evidence, there is objective evidence from which risk can be inferred. Now, the EU now framed that as binding standards for the UK to continue to have access to that data. So the people that were gathering in the room with Cerberus where we were said, well, we had this problem where we had to, what we've done is we had to transpose our policy experts. So one person around the room was a lawyer specialized in data protection law. We had to transpose his deep knowledge of the legislation. What is reasonable suspicion and objective evidence according to the CJEU? So we had to transpose that deep knowledge of judicial developments into business requirements, which we have then coded into the system, right? So this is what Gavin and I in our project describe as the infrastructural Brussels effect, right? So you'll be familiar with the Brussels effect from Anu Bradford, right? The idea that the EU is actually a global standard-setting power because it doesn't only regulate the internal market and the standards it set, because it's such a big consumer market, it regulates transnationally and globally. Now, what we see here is that this extraterritorial effect, so one interviewee with lamentation and with sadness said, we've now left the EU. We didn't arrive in this plane of radical autonomy. We've now just become recipients of the extraterritoriality of EU law, which is not just a legally binding requirement on your governments and courts, whatever. No, it actually becomes an requirement that becomes coded into your system. So the Brussels effect obtains a kind of infrastructural dimension, right? It becomes coded into the border control system. Now, this is a very happy, clappy EU law story. Every EU lawyer thinks this is a massive victory. They left us, but they thought they were gone. And then we came back in, we leveraged our data, we brought it, the law came with the data, and now not only will they be bound by the law for X amount of years, but their whole system, the law has now become part of their infrastructure, of their socio-technical system, right? So it now lives a much more entrenched, longer life, etc. Now, we don't really quite go with that happy, clappy story. So in a piece in Computer Law and Security Review called The Infrastructural Brussels Effect, that was the paper before this one. Please read it as well. Very quickly, these data analysts kind of, it didn't take them the whole Martti Koskiniemi from Apology to Utopia route 500 pages to realize that the law is relatively indeterminate, right? So one of these, the data analyst from BAE Systems said, yeah, well, the TCA was clearly not written by a data analyst. Because a data analyst would never have got these rules on data retention, for example. It's absolutely essential to algorithmic learning. But there's a lot of nuance behind those paragraphs and clauses, right? The beautiful statement during the interview. So you had these classic legal principles, reasonable suspicion, objective evidence, right? So rather than that actually forming a constraint on the development of their system, Cerberus just becomes a new sort of logic by which a data-driven distillation of patterns, right, of clusters of data points, becomes an enactment of what reasonable suspicion actually entails. So it's not that the law poses a constraint on the development of the socio-technical system. It's the inverse, that the socio-technical system now actually becomes determinant of what the legal principle, which is indeterminate and open-ended, what it actually comes to mean. So what we see at this point is that the infrastructural Brussels effect is both a process of norm diffusion as well as socio-technical mediation, right? Where we see a new form of regulatory ordering that has Cerberus at its core. Now, why is this conceptually, I think, interesting or important? So there is this debate going on in international legal theory on infrastructure, legal infrastructure as regulation. Now, one version of that conceptual theoretical debate is the extent to which infrastructure itself is actually a form of regulation. So people at NYU, Benedict Kingsbury and that group have this InfraReg project, infrastructure as regulation. For example, a speed bump in a road, right, on a road is actually a form of regulation. You're doing basically speed regulation, not by a policeman, but just by a bump in the road. So infrastructure has a regulatory function. Now, in the world of technology, this is very often described in terms of code as law, right? So maybe we don't need lawyers and courts and tribunals. Maybe we can just enforce the rules through a kind of computational architecture. Right? And this has a kind of interesting theoretical background. People like Bruno Latour, Where Are the Missing Masses is an important piece in that context. The work of Jeffrey Bowker and Susan Leigh Starr, sorting things out. The kind of idea that lawyers are too indulgent of their own sense of normativity and their own sense of the law. And if we really want to understand regulatory forces in our society, we don't only have to look at law, the symbolic, the interpretative, the hermeneutic, but we also have to look at the material, the socio-technical, the infrastructural, right? Where materiality, infrastructure is its own sense of normativity. And there is, of course, Cerberus is maybe quite a good example of that, right? So as I just said, reasonable suspicion, objective evidence, the way that these terms gain meaning is not really a legal process, but more one that is infrastructurally, socio-technically shaped and mediated. So these are some of the quotes from Benedict Kingsbury's piece that you see here, Introduction to ACIL and Bounds. The infrastructure itself comes to define how law really works. So this is one way that you could define Cerberus. The infrastructure of Cerberus itself comes to define how law really works and shapes what legal rules and policies are even attempted. Infrastructures may cut across legal regimes, but they could also just displace them, compete with them, etc. So one kind of legal anxiety that is lingering here is that the infrastructural, the code, the algorithmic is kind of displacing, taking over law as a form of normativity in our contemporary societies. You could also flip the script though and not only think, well, infrastructure is law, but also law as a form of infrastructure. So our piece in the German Law Journal was part of a special issue by William Byrne, Thomas Hamilton Hansen, and Nora Stappert, where they introduced this concept of legal infrastructures, right? Very much in line with sort of Bruno Latour's idea in La Fabrique du Droit. Seeing law not only as textual, but also as deeply material. Law is shaped by this work by Sophia Stolk and Renske Vos here in the Netherlands on legal architectures, etc., etc. So where you can think not only of infrastructure as law, but also law as a form of sui generis infrastructure. Now, that's just setting a little bit the stage of the debate to then say that in our paper, we kind of try to blow this up and to blow this dichotomy up. So we develop what we describe as an infra-legalities perspective, where we decenter both law and infrastructure as sort of stable categories of social thought or theorization. Rather than trying to materialize the law, to give a kind of material shape to legality, or to sort of think of infrastructure as a particular legal form. And that's a quote from Alain Potage in a piece called The Materiality of What? We begin with the extensive potentialities of materiality and ask what becomes of law if we try to hold these potentialities open. What are, a little bit of a niche Foucauldian language, but just stay with me for a minute. What are the rhizomatic dispositifs in which legal forms and materiality are both implicated? So rather than trying to establish the precise relationship between law and infrastructure in different conceptual forms, we try to blow up these categories and see both as both elements and effects of emergent relational compositions. So there, Miriam, you have the new materialist part of the presentation, through which agential boundaries are drawn and through which distinct specific governance formations emerge. So this our infra-legalities approach then becomes a study of emergent dispositif in which both legal and infrastructural elements are metabolized, which provides us, we think, with a novel account of governmentality, agency, power, and responsibility. That's very abstract, but it's the stage for what we call then the heart of the article, the dispositif of speculative suspicion. So that's what we want to get at here. Dispositif is a concept that comes from Foucault, of course, that points to a particular form of governmentality, and the kind of relational qualities of that dispositif are very important. So for Foucault, it didn't really make sense to think of power coming from that centralized sovereign agent, but for example, dispositif of security, sexuality, biopolitics, these typical Foucauldian formations, they had legal and material and technical elements and discursive elements tangled up in them, but they were all kind of metabolized within that relational formation. So we're thinking about here the dispositif, or we invented the dispositif of speculative suspicion. Now, that brings us back to the split between Helios and Cerberus, right? Helios, the watch list, the known, the old way of doing things. Cerberus, the unknown, the standard of preemptive security. Okay, so there are a couple of features of this speculative suspicion that we describe in the article. One is that this dispositif of suspicion is fluid and relational. The question that is asked here is not, has someone conducted an act that entails criminal responsibility? Or does someone display certain stable characteristics that are associated with crime, terrorism, security threats, illegal overstaying, etc.? No, the question that is asked is, does that person's past behavior and past data trails exhibit a pattern that we are interested in? So, a long quote, one of the capabilities that we need to build is something that is called a network graph, where we start to create associations between different entities. If we just looked at someone's data, right, particular individual characteristics, she would go straight through. But if we look at them in context with what else we know, we might have a chat. It's not quite guilt by association, so the orientation towards the pattern, the relation, the cluster, the anomaly. It's not quite guilt by association, it's a very telling quote, but it's concern by association. Right? Now, importantly, this orientation towards the pattern and anomaly does not only work on a general societal level, right? Patterns of anomaly or suspicion emerging societally, but also in relation to a person's own individual behavior, right? So does what you do now or what you want to do, is that anomalous to the stuff that you yourself normally do or have done in the past? Now, important, and that's the fluidity of the risk assignment, is that these standards continuously evolve. What is a pattern of suspicion today might no longer be a pattern of suspicion tomorrow. It's not about individual characteristics. So it could be, for example, that the combination between what you choose to eat on the plane and when you have booked your ticket and where you have traveled to in the past 5 years and your gender and your age and your country of birth, all these things together and a particular combination signal a propensity, a pattern of risk. But that doesn't mean that your country of birth in and of itself is an indicator of risk. It's only the relational composition of these data points that signals that pattern or that anomaly, etc. Oh, damn, okay. But it's good, yeah. So, this is a really long quote, but let's kind of go through the story together in complete contrast to the time indication that I have just received. So this is actually one of the Cerberus designers telling us that they're not racist, right? So we'll come back to that in a second. So we can very transparently say, they say, that we have not told Cerberus if your destination equals Jeddah plus this time. So this is, of course, about, for example, Muslims traveling to Jeddah plus this. So Jeddah plus this time of the year, then inference equals. So that would be kind of discriminatory, right? That's the idea. So this is not what we're doing. We're just taking all of the data. We don't pre-filter it. We take the whole lot and then we ask basically indiscriminately, are these things that you're doing risky? So they're not looking, that's the point, they're not looking for specific indicators of, if you go there, that would be the old rule-based system. Human intelligence tells us that if you go to Jeddah during that time of the year, you're probably on a pilgrimage, etc. So there's a kind of risk associated with that. That's the old kind of rule-based system. This is not this is not the business that they're in here. The only thing that we're looking for, they say, is abnormality. We don't care that you're traveling to Jeddah during that time of the year. What we care about is that you normally always go to Mallorca, and this time you go to Jeddah, right? So it's not per se, it's not the rule-based risk indicator, it's the anomaly, the pattern. That's the kind of guilt by association. So, interviewer, so you're looking for the anomalous, an anomaly. Yes, a behavior that is of interest. What are the characteristics of these movements which indicate that they are risky? Once we've identified that, the movement or the travel, then we've established a pattern. Now, this of course raises massive political problems, we think, at least, right? So it's a form of social sorting, of classifying people in categories of risk that is not based on stable legal categories against which you could potentially defend yourself, but on relational associations between data points, right? patterns, anomalies, concerns by association. Now, this raises significant legal and political problems. How do you defend yourself against assignations of a risk score based on inferences that are drawn from intrinsically innocuous, involuntary, long-forgotten data trails, right? So you can't say, I haven't done that, because what you've done doesn't really matter. What you would have to say is, no, I wasn't there at that date in combination with my age and what this other person had done and what I normally do, right? It makes no sense. It also creates the impossibility of collective action. You will never know, you inherently cannot know who you find yourself within the cluster, right? In the cluster of data points. The risk category of which you are part is not really a phenomenologically existing one. It's just a temporarily tied together bundle of data points. So you never know who else is in that risk group with you. Just like you will never know who else shares your Spotify mood profile, of your Amazon consumer-based profile, or even in the context of Israel's algorithmic targeting tools in Gaza, you never know what these people with whom you find yourself on the kill lists, what they actually have in common with you, because it's not about commonality of intent or purpose, right? Here we come with Henning, right? So a third essential element here is that if the orientation of the system is towards the anomalous, if the problem is you're normally always going to Mallorca, but now you're going to Jeddah, what becomes dangerous in the system is spontaneity, right? The unexpected. I do something that is not intrinsically behaviorally scripted for me, right? I make an unexpected movement. The very notion of the unexpected, the anomalous, the spontaneous is now associated with the high risk. So as Henning in this piece, the top of the title is not there. You would have to say it, Henning. I don't know it by heart.
It says self-determination in the age of algorithmic.
Voilà, okay. And the European Journal of Legal Studies, where Henning makes the very powerful and, in my view, entirely convincing argument that the real danger of these systems is that they erode the conditions of spontaneous action, which in the political theories from Rosa Luxemburg to Hannah Arendt, as he argues, is the very beating heart of self-determination. The spontaneous, like what Hannah Arendt called this notion of natality, this is the precondition for political action. If the spontaneous, the anomalous is foreclosed, this is the end of the political, right? So Hannah Arendt has this famous critique of on behavioralism, where she says where human beings are reduced to a bundle of reflexes. And this is kind of precisely what the Cerberus system entails to do through this notion of anomaly. But also it entails the resignification of racialized violence. So let me explain that. How do you build an anti-discrimination claim against a normal system? You would say, well, they have made a decision causally on the basis of a protected characteristic. So if the system would be Jeddah plus this time of the year means this risk score, you can perfectly build an anti-discrimination claim, right? Because you would say, well, the only logical inference of Jeddah during this time of the year is a classification based on religion, on the basis of which you have given me a high risk score, I can build an anti-discrimination claim. But as Louisa Moore argues in this fantastic piece, through its logics of feature mapping and data clustering, the state has loosened its reliance on defined racialized characteristics, expanding the scope for the emergent racialization based on inferred attributes. With Stuart Hall, the floating signifier of race, which never had any biological or ontological essence in the first place, is now algorithmically resignified. But in a system that doesn't work on the basis of specific racial categories or characteristics, but just based on anomalies, patterns, and inferred attributes, right? The liberal norms of protected characteristics, which were always already insufficient, will simply be entirely useless now. Okay, I'm doing terribly time-wise, but I'm gonna kind of conclude. Can I have like 10 minutes more with that?
Max 10. Really
That
max.
gives us half an hour?
No less.
Okay, let's do 6, 7. So the second feature, and that's the last that I want to highlight, is brings us to an important kind of discussion on where does power, accountability, responsibility reside in this system? So I think in our law and technology, international law and technology repertoire, we're way too often caught in a kind of binary, right? Either we have the human in the loop, on whom we can project ideas of control, responsibility, ownership, or we have this notion of the agency of the algorithm, right? So this is the kind of science fiction, dystopia, the Frankenstein problem. We have created something that we can no longer control, and it's making decisions autonomously, and it's sort of spiraling behind our control. So when we were interviewing these Cerberus people, they kept saying to us, but look, Cerberus is really a rules-based system. We set the standards and then it kind of executes. While other people, like Louisa Moore, where I think she goes in the wrong direction, is like, no, these systems are jurisgenerative, they continuously, autonomously create new rules, and we have no human oversight or control over that. Now, sort of our sociolegal study reveals a completely different picture, right? A picture where it's all a little bit steam-powered behind the engine, behind the scenes, which was a quote from them themselves, and where we could trace neither the kind of total control of the human in the loop, nor the total autonomy of the algorithm, but the kind of composite, mundane, more than human circuits by which a risk rule is crafted. So this is the best I could do. I couldn't really do it on a decent slide. But this is the targeting rule. So this is the risk-based targeting rule that Cerberus creates. Now, first of all, what happens in the system, the first stage of Cerberus, is that they go to the targeting teams and the frontline officers, and they, in the terms of one of the interviewees, so this was someone from BAE Systems, who said, what we do is we suck out all the professional knowledge of the people we already employ. We get it out of their heads because they know it better than we do, and now we're going to codify it and we're going to standardize it. So the first iteration of the algorithmic risk rule is just a kind of bad sociology. So they literally went around with surveys and questionnaires and sat down and sucked out the professional knowledge of these people who were already being employed there. So this is part of the interview. Where we ask you then use the discretion and the decisions of frontline officers to do data classification and labeling of the algorithmic model, which is then fed back into Cerberus. Absolutely, they say, because once we've done that, we've now won over these frontline officers. They're now part of us, and they now become a huge asset, because now they're telling us when they classify the data for us. And this becomes a virtuous circle. Remember the virtuous circle, because data is now classified in the right way, and we ingest it, which means that we don't have to spend time classifying it. And the data is now classified in the right way, and we can start to adopt supervised and non-supervised learning models. That will become a little bit more clear in a second. But important here is what one person said, the thing that really sinks projects like Cerberus, because we have to remember this is a big administrative reform project, is not the technology, it's the lack of adoption due to fear. So the people who will have to use it, we have to win them over. Okay, so the first stage is you suck out all the professional knowledge of people you already employ, you codify it, standardize it. Importantly, there is also a cultural aspect to it, right? So all of a sudden, these BAE coders have become kind of like little ethnographers in the home office, right? There's a cultural aspect to it, which is to say, the size of the transformation that we're given to you is small. It's not scary. You can use it and let's get on with it. So that's what they're saying to the frontline officers. Now, the second stage is that now you have the first variation of your risk rule, which is basically a condensation of the professional knowledge. The second stage is that risk analysis will be about machine learning-based optimization. So we know that our weighting of the risk rule will be off, it will be wrong, it will not work. But we can use artificial intelligence to kind of tweak and tune the risk rule, right? This one risk rule is not really working. It selects the wrong people. It lets the wrong people go through. So we have to use AI to optimize our risk indicator. Now, the fourth stage is that the third stage after the optimization is when machine learning, AI, becomes really a source of what they call hypothesis generation, right? Where AI is not just testing if your risk scores that you have sucked out from the professional people's head is actually working well, but where AI finds you patterns and anomalies autonomously. And supervised learning tools can run over all the data and find patterns where they find you something that no person would have found you, right? So we talk much more about that, but the essence here is what someone described. The data is effectively like a snowball. It goes through different parts of the process and it accretes additional contributions from the system or from the person who's looking at it. Over time, that will lead to a place. So imagine this is how a rule is made who decides who gets to enter or who doesn't get to enter. Over time, this will lead to a place where we will have this flow of data from initial acquisition all the way through the operational response, enter or non-enter, which we can then all feed back in. So what we have here is not a space where a parliament gets together and it sets a rule. It's not a space where an administrative agency develops a rule. It's a space where we have a circular, more than human cybernetic chain of feedback loops, right? So we have professional expertise becomes a rule. The rule becomes algorithmically optimized. The machine learning system finds a new pattern, a new rule. It goes to the frontline officer. The frontline officer says that's a bad rule. That rule gets it. So we never have like a centralized moment of agency where someone decides. We just have continuous feedback where actually error, a mistake, is very generative. Error itself is a juris-generative part of the process, right? Making a mistake becomes almost a law-making action because it just feeds back in, right? So targeting rules here emerge only as speculative signals that are temporarily tied to patterns that meet a certain threshold value. Or as Nick Seaver, a phenomenal anthropologist of the algorithmic, describes it, what we see is a steady accumulation of feedback loops, little circuits of interpretative action closely knit together into a vast textile. And so I'll end with this as a kind of normative conclusion on that. So what we have here has major implications for questions of legal change, agency, and accountability. So back to you, Ingo, and like sort of your work with the interpretative community and the semantic shift, right? So this is the model of legal change that we have here, right? So not interpreters, humans gathering around a rule and sort of changing the law as a form of collective interpretative labor, but a more than human chain of feedback between human and non-human elements, right? This becomes a new kind of standard setting or juris-generative enterprise, where I think Louisa Moore is totally right, argues the human in the loop, there are tons of humans in the loop, right? There are humans here, there are humans there, there are humans here. So we have no shortage of humans in the loop. The point is just that we have no humans in the loop where we can reasonably assign centralized points of decision-making agency and therefore legal responsibility. The human in the loop from sort of liberal theory is an impossible figure, she argues, but we can add it's a seemingly necessary legal fiction. She argues in an amazing book, Cloud Ethics, humans are lodged within algorithms and algorithms within humans. We're always in these systems part of that more than human composition. But as Jay Goldenfield and Jen Razo argued, the problem with that, of course, is that the effect is a continuous dilution, displacement of agency and responsibility. In the feedback loop, nobody really decides. So what we need, we argue in the piece, is a new register of legal agency and accountability that thinks in this context in compositional, infrastructural, socio-technical terms. Okay, so this is all the amazing stuff that we're missing. Could I? No.
Yeah.
No, and I'll end at the final. Can you just go? I can't go back anymore.
Uh-oh.
Yeah, just that one. Just to conclude, maybe we can leave it on this slide. Yeah.
Okay.
So this is, as you see, I'm very excited about the empirical project. I think many parts of the kind of socio-legal material we revealed is not only a kind of original socio-legal study of Cerberus as a kind of decision-making system, but I think it's telling for the kind of questions that we face in international law and technology and legal theory more generally about the distribution and displacement of agency, right? Where does legal transformation come from? The intricate and difficult relations between the legal and the infrastructural as different sites and locations of normativity. The significant political problems that we face here in terms of the erasure of spontaneity through the focus on the anomalous and the abnormal and the pattern. A new form of governmentality that is not based on you have done something wrong in the past, so you're punished in the future, but more a speculation on, based on patterns of behavior, what could we speculate, preempt that you might potentially do in the future? So what we hope to have done then in the piece is to kind of raise the stakes of these questions, but also shift focus towards the material affordances of socio-technical systems rather than just standards or principles. So if you're on board with what I just said, and then you think about the AI Act, which is like, oh, we need a human in the loop within that system, or we need that system to be more transparent, or et cetera, that seems to be a kind of very limited normative register of engaging with what's really politically at stake here. I'll end there. Thank you.